This is true.
All rise.
Our audience is spinning as the day goes on. We did? Okay, have a seat. Okay, good morning. It's 10:29 here. Welcome to another session of oral argument with the 5th District Court of Appeal. We had a break here between the second and third cases this morning to have a panel change. I'm Judge Lambert. I'm Brian Lambert presiding. To my right is Judge John Harris. To my left is Judge John McIver. This is our third and last case of the day. It's case number 24-0180. For the record, it's Tuesday, May 6, 2025. 240180. Ecio Rodriguez versus Matthew Anderson and Joshua Anderson. Each side will have 20 minutes. When the yellow light comes on, we'll say 5 minutes for rebuttal, and you want a different amount of time. Let our Marshal Aaron know that if you want a different amount of time, he'll set it for you. But when you get into rebuttal time, the yellow light will come on, and I'll tell you that obviously you can keep going as long as you want. If you don't, your aggregate time is 20 minutes. So for some odd reason, you use all your 20 minutes during the first argument, and then out of rebuttal, unless we drag you into that extra time. So. All right, counsel, if you're ready, go ahead, sir.
Thank you. May it please the court, I'm Warren Klobnik on behalf of the defendant below, Ecio Rodriguez. I'd like to reserve 5 minutes for rebuttal. We're here respectfully asking the court to reverse an order that granted the plaintiffs a new trial in this case. Understanding the deference afforded to trial judges in granting a new trial, we believe the judge did abuse his discretion in this case. First, the record doesn't support that there was any appeal to financial sympathy in this case. Defense counsel's comments.
I'm just slightly curious. When you were preparing your presentation today and you introduced yourself as counsel for the defendant below, was that a conscious decision or is that your just normal form?
That is my normal form, and I had not even thought about the connection until Your Honor said so.
Just curious.
But honestly, that's typically how when I represent the defendant, that's how I describe him, even on appeal, not as the opponent. Which gets me into my argument. Referring to the defendant as the defendant, or as defense counsel is representing him, or to his admission of negligence, those are not things that suggest that there is no liability insurance or that he's going to be personally and solely responsible for the judgment. No case that we've been cited to remotely supports that counsel cannot say that. The other thing I would point out is these things were said repeatedly by the judge as well as the lawyers before there was ever any objection or motion. So I would think that this is not preserved as a basis for a new trial. But even if it was, nothing about these comments could be so highly prejudicial and inflammatory as to have deprived the plaintiff of a fair trial, and that would be the standard.
So the reasons the new trial were granted, if I understand it, and fill in the blanks of this is you referred to, I guess it wasn't you.
I may judge it.
The defense counsel, they refer to themselves as I'm representing the defendant, or me and my co-counsel representing the defendant. We've admitted negligence, and the verdict is against the manifest way of the evidence. Those are the bases for the new trial being granted?
Yes.
Anything else that I...
No, Judge.
Okay, go ahead.
And I believe in the answer brief, there was an acknowledgement that it was okay to actually refer to the lawyers as representing the defendant. So that, to that extent, I think they've walked back the things that, or at least part of what they were saying, suggested the absence of insurance.
What were they suggesting that trial counsel should have said as to who they're, I mean, you're a jury and there's the judge says there's a defendant and there's somebody in a suit next to him. How were you supposed to refer yourself as?
Well, at one point, I think plaintiff's counsel said they should call themselves the defense.
Defense?
The defense.
Okay.
So as to somehow, I suppose, include the insurance company in that broader umbrella, perhaps. But that's kind of my point, is these things don't suggest anything about insurance or personal exposure. Trials would be unworkable if you couldn't say these things. Even the judge said these things, and it's on the case study.
Oh, yeah, I assume the plaintiff many times cited in the pleadings or motions, that's the defendant.
Well, right, and there's no question that he was.
He was the one who was sued.
Yes. And as far as the second point goes, I don't know that it stands alone. I think the way I read the order is that these alleged violations produced a verdict that was against the manifest weight. So I would say if you knock out the first one, that takes the legs out from the second one. But even as an independent basis.
Well, the judge even said that the verdict itself did not shock his conscience. It was other stuff that led to things.
Correct. Everything that went on shocked his conscience.
Yes.
The way that was reduced to writing by plaintiff's counsel was, I don't even really understand the way they framed it, but his failure to grant, the error committed by his failure to grant in this trial shocked his conscience. So it was certainly not a comment on the verdict. Everything he said about the verdict was it did not shock his conscience.
So he was shocked because he didn't grant the mistrial. The judge shocked his own conscience for not granting the mistrial.
I suppose, and that's, again, the way he articulated verbally was, my conscience was shocked not so much by the verdict, but everything that went on, which is, it's not specific, and that's what he said. Certainly not by, but he said not so much by the verdict. And I would say to the extent that he found the verdict to be against the manifest weight, that was unsupported by any analysis and findings, and it's unsupported by the record. The jury, on the issues of causation and damages, the evidence was in conflict, much like it is in any case of this kind. The jury heard from the defense radiologist and the defense orthopedic surgeon that there was no objective evidence of any acute injury as a result of this accident. The defense doctor, the orthopedic, said what these plaintiffs suffered was a temporary strain for which 12 to 14 weeks of care was appropriate. Nothing.
That was the medical expense that was awarded. Past medical expenses for that care.
Exactly right. That's what the jury awarded. And nothing in the order or findings by the judge provided any reason why the jury was not allowed to accept that evidence. In fact, he made no analysis at all. What the judge said was, it's for all the reasons argued by plaintiff counsel. And I would suggest that that in and of itself was an abuse of discretion. The judge, before setting aside a verdict in a 9-day trial, is supposed to do an analysis of the conflicting evidence. If there's a problem with the jury's verdict, should explain why the jury shouldn't have been able to come up with the verdict that they did.
Well, I mean, there was a motion in limine to not refer to admission of negligence.
No, that's not correct, and I'm glad I have a chance to address that. The way, in the answer brief, it's argued that there was a motion in limine to that effect. That's not the way it played out. This is the beginning of trial. What was being argued was what should be in the opening instructions. It was not a motion in limine, and the judge ultimately went with what he understood to be the standard, what he called the simplest, which is just to say that there's no issue of negligence. He never said it was not a ruling in limine. It was never a motion in limine. There was no order saying that defense counsel couldn't say admission of negligence. He was just addressing an instruction. And subsequent to that, the judge himself said twice, the defendant has admitted negligence. No, it's not here.
He was choosing that instruction on the tail end of extensive argument about being able to say it.
It was about 4 pages. It was about 4 pages of argument. Plaintiff's counsel did argue that they shouldn't be able to curry favor with the jury, I think is the way he put it, by arguing that.
The judge said curry favor with the jury. I mean, what have he said? These fellows over here, they're not negligent. They weren't the cause of the accident.
Well, that was kind of the point. And I think the argument is to point out how reasonable we're being and to try to win points with the jury. But there's a legitimate reason for this, and you could see in jury selection, it was to try to explain, and this was the question, does anyone think that because we've admitted negligence, damages and causation are not in dispute? So they needed to understand that, just because there's no issue of negligence, are you going to be people who understand that doesn't mean there's necessarily causation or damages? This was a fair point. But
that was the point of the defense.
Well, exactly. So we needed to be able to understand, the jurors are going to be able to make that distinction. But I do disagree that there was any order. You're right, that was the plaintiff's argument behind it, but the judge didn't endorse it. The judge didn't say defense counsel can't say this. He went with what was simplest for purposes of the instructions. And again, the judge himself subsequently said twice without objection or motion that the defendant admitted negligence. And later, when this did come up, the plaintiff's counsel acknowledged. It said, well, Judge, you mentioned that, but we're past that now.
Did the plaintiff's counsel at trial then ask the judge to cure his earlier misstatement? I mean, I'm sounding almost facetious here, but I mean, if the judge has said it twice to the jury, and then it kind of dawned on the plaintiff's counsel, well, you said this too, Judge, we need to unwind this and make it clear. Was there a request made by trial counsel for the judge to do that?
No, not that I can recall, other than to say, and this was really only a secondary point of the plaintiff's argument. His primary one was that by saying those other things, it was suggesting there was no insurance. It was almost a throwaway point that they're occurring in favor of the jury, but we're past that now because Your Honor had said. So it was almost like a non-issue. And in fact, I do want to point out, the order granting a new trial wasn't premised on the occurring in favor issue. It was only what the judge calls the Hollenbeck issues, which is references to the absence of insurance. So ultimately, when he did grant a new trial, it wasn't because of the admission of negligence occurring in favor of the jury. It wasn't the credit claiming issue that we're talking about. I'm prepared to save the remainder of my time unless the court has additional questions for me.
As to the manifest weight of the evidence, basically your position is the trial judge can't act as a seventh juror. There's conflicting evidence. When there's conflicting evidence, that's not against the manifest weight because that's what we ask juries to do, to weigh the evidence in the room.
Correct. And yes. And I think what we're seeing here on appeal is in the absence of any articulated cogent reason why the jury shouldn't have been allowed to accept the defense evidence, what we see in the answer brief is an argument of their entire case ab initio with reasons why this court, as if you were jurors, shouldn't accept the defense evidence. Well, Dr. Zaidi always testifies to that. I mean, if there was evidence to support that, these things were argued to the jury, and the jury heard all these things, and they weighed the evidence, and this entire presentation now about there were reasons why the jury shouldn't have accepted it, those were not reasons ever set forth for why the verdict was against the manifest weight. And there was really no basis to set this aside. I think, to set aside a verdict in this case after a 9-day trial, when the only challenge is, other than the manifest weight, was defense counsel suggested that there was no insurance when it clearly wasn't the case, I think we have the gross abuse of discretion here. So that's the court for us.
Thank you.
May it please the court, Your Honor, David Block on behalf of Matthew and Joshua Anderson. Your Honor, I want to start with the second basis for the new trial here, which is the manifest weight issue. Respectfully, they are not intertwined issues whatsoever. Let's take a look at what the actual new trial order itself specifies. Specifically, the new trial order is at record page 4,227 through 28, and opposing counsel conflates two separate paragraphs. Paragraph 3 addresses the Hollenbeck issue, which is not just about insurance. Attorney Block, who was lead plaintiff's counsel below, when he argued the Hollenbeck issue, it was always a combination of two things. One, it was referring to the individual defendant, and then combining that with attempting to curry favor because of the concession of negligence. So that's paragraph 3. Paragraph 4 stands alone, completely stands alone. It says the court finds that the verdict rendered by the jury was against the manifest weight of the evidence for all of the reasons cited in plaintiff's subject motion for new trial and argued thereupon. Defense counsel...
Is that what the judge said?
The judge indicated as follows on the transcript. He said, I think the manifest weight of the evidence in this case was clearly ignored by the jury. And then he directed Attorney Block to prepare an order reflecting that. And then we prepared the order, and then he reviewed the order, and he signed the order. And it was based upon the motion for new trial. Opposing counsel says there was no fact-finding here, there was no weighing of witness credibility, there was no review of the evidence or the manifest weight of the evidence. That is false. 12 and a half pages, over half of the motion for new trial, were specifically addressed to all of the evidence in the case, the credibility of all of the witnesses, weighing the credibility of the plaintiff's medical treaters versus the two defense medical experts here, and explaining why the overwhelming weight of the evidence supported that for two brothers who were in their early to mid-30s at the time of this accident, and where the car was completely destroyed, all airbags deployed, the side is crumpled in, the front is crumpled in, the back is crumpled in, they were both knocked unconscious. Both of these gentlemen had never had any of these issues previously in their lives. Any degeneration, even as testified to by Dr. Zaidi, was normal, mild degeneration associated with someone in their 30s, not acute herniated right signal herniations in the cervical spine, which is what we have here, and white matter lesions demonstrated by TBIs in this case. So for opposing counsel to say that the new trial order doesn't contain any fact finding is wrong. What the order does is it incorporates the 12 and a half pages that are at record page 4,109 through 4,131. That's actually the full 22 pages of the motion for new trial. The second half of that motion, it is weighing the evidence and it is going through the evidence. Now, I want to get back to a question that Judge Lambert asked.
Before you do that, let me ask
Yeah.
you. In order to justify the granting of a new trial, because of the manifest weight of the evidence, what is it that has to shock the judicial conscience?
Shock the judicial conscience.
What is it that has to
Is
shock?
a different measure. That is with regard to the adequacy or the inadequacy of the amount of damages. That was nomenclature that the judge included at record page 4,337. That is not the standard for granting a new trial based upon the verdict being against the manifest weight of the evidence. The standard for a manifest weight argument comes from Brown versus Stuckey, which is a 1999 decision of the Florida Supreme Court, where the Florida Supreme Court specifically rejected the conflicting evidence standard that is requested here today. That violates decades of Florida case law. It's completely wrong. They're walking you into error by arguing that. Brown versus Stuckey says it doesn't matter whether there's competent substantial evidence supporting the verdict. Once the trial judge makes the determination that the evidence is against the manifest weight of the evidence, a reasonableness test is applied. And simply because opposing counsel comes in after the fact and can point to evidence in the record that supports the verdict, that does not equal an abuse of discretion, and that does not mean that the trial court, given its superior vantage point, and Brown versus Stuckey points this out, the trial judge who sits through the trial, sees the witnesses, is supposed to judge their credibility and weigh all of the evidence. So saying that it's exclusively the jury's role to weigh the evidence is wrong. Brown versus Stuckey, which goes back and reaffirms what the Florida Supreme Court said in Cloud versus Fallis, a 1959 decision, says that the court must grant a new trial whenever, in its sound discretion, based upon its superior vantage point, it determines that the verdict is against the manifest weight of the evidence.
Use of discretion standard. I mean, to me, it sounds like a trial judge can simply sit as the seventh juror, which to me this record abundantly shows is what he did, and simply say, well, I think this is against the manifest weight of the evidence, even though the defense puts on the experts that says there's no permanent injury, this is a sprain injury, and I just decide it's the manifest weight of the evidence, and then the appellees come up to the appellate court and say, you can't do anything about it, Judge.
Respectfully, Your Honor,
That
this
sounds
is...
like exactly what you're telling us, so you go right ahead.
Yeah, so I'm not telling you that, Your Honor, and in fact, reviewing, you can shrug, that's fine. I've read the entire record multiple times. I've read all of the medical testimony in this case, and I want to go through some of the facts. I would also refer, Your Honor, specifically to the Hahn versus Medeiros decision from this court.
Be Stuckey for a second. Does that not say a new trial may be ordered on this ground only if the verdict shocks the judicial conscience? Isn't that a quote from Brown v. Stuckey?
That shocks the judicial conscience quote, I believe, is the portion of Brown that deals with motions addressed to the excessiveness or inadequacy of the amount of damages, not the liability portion.
It's the verdict that has to shock the conscience, not
When you're
on the trial.
talking about the amount of damages. Here we're talking about liability as well. So, getting back to your question, Judge Lambert, Hahn versus Medeiros, substantially similar facts to this case. Decision from this court, not mentioned by defense counsel in their reply brief. That is the same situation here. Judge Sawaya, who authored that opinion, explained there was conflicting evidence, and the court did not sit as a seventh juror because it went through, and even though there was some evidence supporting the verdict, there was substantial evidence that did not support the verdict. And the trial judge, under Brown versus Stuckey, is the one who is in the superior vantage point, not the appellate court, not trial counsel, the judge. That is not sitting as a seventh juror. Let's go through some of the facts. And I respectfully disagree that anyone was sitting as a seventh juror or that there's an abundance of evidence that supports the verdict here. You are dealing with, I would submit, look at the photographs. Look at the photographs of this accident. This is a significant impact. Both of these gentlemen who are in their early to mid-30s are knocked unconscious. They go to the hospital immediately after the accident. They start medical treatment within 48 hours.
I mean, not that it really matters, but there was a lot of debate as to whether they were even unconscious for a second, right? That's not a stipulated fact by any means.
There was uncontradicted testimony from them. What they refer to are statements of equivocation from EMTs who weren't there when the folks were unconscious at the scene. But the two brothers both testify that they were rendered unconscious, and consistent with that, their brain MRIs show white matter lesions to the level of a 60 or 70-year-old adult. These gentlemen were in their early to mid-30s. And by the way,
What is the scale that went from 1 to 15? 15 means no.
The Glasgow Coma.
you're right, that's a consciousness scale that was administered by the EMTs after they showed up, after the brothers had extricated themselves from their vehicle. Josh woke up first, woke up Matthew. Josh then had to be extricated from the vehicle by a bystander because the door wouldn't open. He had to be pulled out. He had a gash on the back of his head. He had broken ribs. And as the testimony from all of the medical witnesses showed, even Dr. Zaidi, the defense CME, neither of these brothers had ever had any MRIs in their past. Neither of them had any significant cervical or lumbar pain. Neither of them had any brain issues in terms of lesions demonstrated on MRIs. Let's talk about some of the concessions from Dr. Zaidi. Dr. Zaidi was forced to admit the following on cross-examination. Doctor, at the very end of your testimony, you told us it's your opinion that Joshua Anderson's pain should have resolved within 12 to 14 weeks, correct? Answer, his condition of his strain, yes. Question, okay, it didn't, did it? No. Then he says the same thing about Matthew. Then he's asked, did either of these brothers, throughout the history of their past lives, ever have any of these complaints with regard to their neck and lower back? And he answers, 0 diagnoses, 0 complaints. That's at transcript page 1517 through 18. Then he's asked as to Matthew Anderson. As far as Matthew Anderson, I can go through these one by one if you want, but to save time talking about the before picture, there were no chiropractic treatments, there were no physical therapy treatments, there was no MRI of his neck, there were no disc herniations diagnosed at C3 through 4 in his neck. There were no disc herniations at C5 through 6. There were no disc herniations at C6 through 7. There were no MRIs of his low back. There were no disc herniations at L3, L4 in his back. There were no disc herniations at L4, L5 of his back. There were no EMG, SAS, NCV tests. There were no recommendations for neck or back surgery. There was no pain management treatments. There were no neurosurgeon treatments. There were no orthopedic surgeon treatments. There was no cervical collars ever that he had to wear. No wrist or hand braces for carpal tunnel. No recommendations for injection therapy. No cervical medial branch blocks at C5 or C6 or at C7. No diagnosed muscle spasms. No recommendation for epidural steroid injections. No recommendations for lumbar medial branch blocks. No trigger point injections. No occipital nerve block injections. No 1-level anterior cervical discectomy infusion. No 2-level anterior discectomy infusion. No carpal tunnel syndrome as far as any records that you've ever seen that exist anywhere in the world before. Answer, yes. He then made the exact same admission regarding Joshua Anderson. So Dr. Zaidi, who the trial court judged his credibility on the stand at a sidebar, he said, Dr. Zaidi, you are obstreperous. You are not answering the questions. You are evading. And he said the same thing about the defense radiologist, Dr. Bush. He acknowledged on sidebar that both of these gentlemen couldn't answer simple questions and were evasive. That's judging the credibility. Those same things were put in the 12 and a half pages of our motion for new trial, which the judge agreed with at paragraph 4, adopting all of the bases cataloged in the motion for new trial. I want to go back to the case law because I disagree again if this has anything to do with acting as a seventh juror. Hahn versus Medeiros, there's a specific quote. In sum, even if there's competent substantial evidence in the record to support a jury's verdict, as there was in this case, a trial court's order granting a new trial must be affirmed if reasonable persons could differ as to the propriety of that order. The fact that there may be substantial competent evidence in the record to support the jury verdict does not necessarily demonstrate that the trial court abused his or her discretion. And Judge Sawaya pointed out there was conflicting evidence in Hahn versus Medeiros. The defense experts said these are soft tissue strain sprains that resolve within a matter of weeks. In contrast, the plaintiffs presented the same type of evidence here: objective imaging and testimony from all of the medical treaters showing that the injuries for the plaintiff did not predate the accident. Dr. Zaidi also admitted he had no alternative cause for the continued pain that both brothers were experiencing, for the herniations that appeared on their MRIs. He had no explanation. He simply said, one, both surgeries that they had were unnecessary. bringing in the concept of Stewart versus Hertz and medical negligence, for which the jury received instruction. Under 501.5C, they were instructed that if there's testimony that there is medical negligence and the plaintiff followed the reasonable recommendations of his or her doctors for purposes of obtaining medical treatment, then the defendant eats the medical negligence. So Dr. Zaidi saying that these surgeries were somehow unnecessary proves the point. Going to, quickly, Dr. Bush. So let's talk about Dr. Bush, the defense radiologist. He had no opinions on injury causation or permanency. He acknowledged that he did not review all of the plaintiff's medical records. Instead, he only relied upon those that were cherry-picked. He agreed with the terminology cherry-picked, by the way. He was asked, were these cherry-picked? Did you rely upon cherry-picked defense exhibits regarding medical records? He said yes. That was his answer. Not mine, not trial counsel's, no one from our side. Dr. Bush also readily admitted he didn't perform clinical correlation or differential diagnosis, and most significantly, he acknowledged that the MRIs for both brothers were abnormal, specifically at pages 2025 through 26 and 2038 of the trial transcript. He acknowledged that the MRIs for both brothers were abnormal. Getting back to the case law, Smith versus Brown, 1988 decision from the Florida Supreme Court. In addressing a manifest weight motion, the trial court addresses witness credibility along with the weight of the other evidence. A mere showing by the opponent that there is evidence in the record supporting the verdict does not equal an abuse of discretion. Instead, you apply the reasonable person test that Judge Sawaya applied in Hahn for this court, which stands for the proposition that if a reasonable person reviewing the evidence in this case could agree that the trial judge had a basis in the record to believe that the verdict was against the manifest weight of the evidence, then there is no abuse of discretion. Same thing, Trujillo versus Uniroyal Tire Company, 2000 decision from the Florida Supreme Court, 753 Southern 2nd, 1256. It again rejects the exact same conflicting evidence, competent substantial evidence standard that defense counsel argues here, and it says that is not the test for manifest weight. Instead, the trial judge, given his or her unique position of having viewed the testimony and considered all of the evidence in the case, is permitted to determine even where, quote, it is not clear, obvious, and indisputable that the jury is wrong, the verdict is against the manifest weight of the evidence. That is repeated over and over again by the Florida Supreme Court. Even if this court says, oh, there's conflicting evidence, the jury is not clearly wrong, it's not obvious the jury is wrong, it's not indisputable the jury is wrong, that standard went up to the Florida Supreme Court specifically in Cloud, in Brown versus Stuckey, in Trujillo, and in multiple other decisions. And every single time the Florida Supreme Court said, no, that is not the standard. It doesn't matter if there's conflicting evidence. If the trial judge who actually sat through this, heard the testimony of the witnesses, determines that it's against the manifest weight of the evidence, what you're supposed to do on review is you're supposed to look at whether there's evidence supporting the trial judge's exercise of discretion, not looking at whether there's evidence that supports the verdict. Because as Hahn says, as Brown says, as Trujillo says, even where there's evidence in the record that supports the verdict, that does not prove an abuse of discretion if there is evidence in the record that supports the trial court's conclusion that the verdict is against the manifest weight of the evidence. E.R. Squibb and Sons versus Farnes, 1997, Florida Supreme Court, 697 Southern 2nd, 825. Again, Florida Supreme Court holds in addressing manifest weight of the evidence motions for new trial, the trial court weighs witness credibility and all of the evidence. Just like the jury does, trial court has a favored vantage point, and a mere showing of record evidence supporting the verdict does not equal an abuse of discretion. And the case goes on to say, in that case, although there was evidence supporting the verdict, there was extensive evidence supporting the trial court's new trial order. So, even if there is evidence supporting the verdict, once again, if there is extensive evidence supporting the trial court's grant of a new trial based upon manifest weight grounds, that requires affirmance under the reasonableness standard that is required under Brown versus Stuckey.
Before we run out of time, can we circle back to the other issue?
Yes, sir.
As someone who presided over countless jury trials, always referring to the person being sued as the defendant. When did that change? When did that become so problematic?
So I want to point out, Your Honor, it's the combination. And by the way, opposing counsel starts out by saying the issue is not preserved because the first few times the defense counsel identifies himself as representing Mr. Rodriguez, there isn't an objection. There isn't an objection for a particular reason. The argument below was that combining two things was a Hollenbach violation in this context. One, admitting fault. And the reason why admitting fault and then saying that over and over again in front of
Does the council ever admit fault, or did the judge do that?
the judge only did it with regard to the jury instruction and his paraphrasing of the jury instruction. That is a red herring. When you look at the record, specifically record 3595, 3665, and then transcript pages 236, 546, and 2501, when the judge mentions that negligence is not an issue, he is providing an instruction. When defense counsel does it, they are attempting to curry favor with the jury by saying, we are reasonable, we have admitted fault. The only reason we're still
It has
here.
nothing to do with Hollenbeck.
It does, because they're saying this defendant has admitted fault, and the only reason we are still here is because they are fighting us on him, what the amount of damages is that he's going to be responsible for at the end of the case. That was the argument that Attorney Block made, which is why the first objection in motion for mistrial doesn't come until page 379 of the transcript and then continues through 389. And by the way, the trial court below said the objection was timely made and that it was repeatedly made and that the court had reserved upon it. This argument that somehow it wasn't contemporaneous or there wasn't a timely objection made, that was not an argument that was made below. That was not even addressed. Defense counsel has agreed that the mistrial motion was made. He simply disagreed with the basis for the mistrial. There's actually 6 instances in which this is argued. Transcript page 379 through 89. And the quote that brings this up is, what actually brings us to court is not the fault of Mr. Rodriguez, but it's the nature and extent of the injury sustained. That, combined with identification of only representing the individual defendant, is what was contended to be the Hollenbeck violation here. And by the way, let's talk about Hollenbeck itself. So the standard that defense counsel wants the court to apply is there must be an express mention that the individual defendant is going to have to pay for the verdict or an express mention of insurance. However, in Hollenbeck itself, there was not an express mention. Instead, what the defense counsel said is, I'm a consumer justice attorney. I represent John Hooks, not some fancy company, not a conglomerate. That was the statement that was made in Hollenbeck. And then
Which was called egregious in the opinion.
it was.
You think just saying I represent the defendant is as egregious to different levels?
When you combine that with over and over again, and I also, really quickly, sorry, I want to get back to this. The objection and the motion in limine with regard to acknowledging fault, a fair reading of transcript pages 4 through 8 is that defense counsel wanted the ability to state that they admitted fault to the jury in the statement of the case and then repeatedly throughout. The trial court at the end of that argument said the defense motion is denied. So there was an in limine ruling. Getting back to answering your, I see my time is up, Your Honor. Do you want me to answer your question?
Go ahead.
Okay. So to answer your question in terms of going back to Hollenbeck, this situation is akin to Lindsay versus Rayburn, which is a Hollenbeck progeny decision from the 1st District, 2011. In that case, the defense there argued both the admission of fault and then tied that to who was responsible for paying for the verdict. They said repeatedly that the owner of the corporate defendant there had admitted fault and that he would be responsible at the end for the damages that the jury determined. And final point, Your Honors, and I appreciate your time, we don't have to doubt here the effect of combining the admission of fault with the identification of representing only this individual defendant, because prospective juror Hernandez, there was no evidence that Mr. Rodriguez suffered any injuries in this accident. There was no evidence that he had any problems other than having to pay for the verdict. She expressed in front of the entire panel that she felt sympathy and was sad for Mr. Rodriguez. The only thing Mr. Rodriguez was facing was civil liability in this case. He was uninjured. Thank you for your time, Your Honors. For these reasons, we would respectfully request that you affirm the trial court's exercise of its discretion to grant a motion for new trial. Thank you.
Counsel, you have 9:36, if you would like to use that.
Thank you, Judge. I'll try to be brief. With regard to whether the two grounds are related to one another, paragraph 3 of the new trial order says, because of these multiple Hollenbeck violations, the jury clearly ignored the manifest weight. So I do think they're linked. And again, I think if you can discredit the one, the other one's got to go. But again, even as an independent matter, I think what we've just heard, to use their words, a cherry-picked version of tidbits supporting their case over the course of a 9-day trial that don't demonstrate any proper exercise of discretion. Now, they say that what the judge did appropriately adopted the plaintiff's motion. Nothing in the plaintiff's motion provides any reason why the jury was not allowed to accept the defense evidence. Nothing in there supports the judge's ruling, even if it was appropriate to simply adopt the motion. The fact that the plaintiffs in the past had no prior treatment is not the issue. The reason the diagnosis of the defense experts was that this accident, there was no objective evidence of an acute injury or aggravation. That's what their finding was. And whether or not they had conditions treatments in the past, it was undisputed by everyone that they had degenerative conditions and herniations already. The fact that they may not have had treatment for them doesn't matter. And again, the past is not really the issue. It's that there was no objective evidence of an acute injury from this accident. As far as the brain scans go, both men had normal brain scans after the accident of one type or another. One in a CT scan, one in an MRI, both read as being normal. Only when the expert radiologist for the plaintiff, Mahan, comes in, does he find these white spots. He can't find causation, though. The only reason that why there's any plaintiff testimony as to causation is subjective complaints. Things like memory, concentration. Matthew Anderson, though, years before this accident, had a variety of these issues: memory, concentration, sleep problems, all these things in his VA records that he didn't disclose to the defense. So those things were all pre-existing for Matthew Anderson. As far as Joshua, the claimed memory problems, not a single complaint of memory problems for over 3 years after the accident. In their discovery responses, nothing about, they're asked, tell us all the things that are wrong with you. Nothing about brain, nothing about memory, nothing about concentration. The jury had every reason to disbelieve in these problems. As far as alleged problems with Dr. Zaidi's testimony, again, he said all these men had was a temporary strain, 12 to 14 weeks. And then the question is, well, but they still have pain, right? I suppose yes. Well, Dr. Zaidi doesn't diagnose pain. He diagnoses conditions. Pain is subjective. The jury had no reason necessarily to accept that. It didn't undercut his opinions that the objective evidence showed nothing more than sprains or strains. As far as Bush goes, and again, I'm just trying to hit some of the points that were said. The claim was even Dr. Bush, the radiologist for the defense, showed abnormal MRIs. Yes, he did. What he said was there were desiccated discs that pre-existed the accident and weren't caused by the accident. This is a case of a judge without any cogent reason acts as a seventh juror and sets aside the verdict. The Hollenbeck violations don't exist. There was nothing there to that effect. And this was an abuse of discretion. If there's no
Well, yeah, I mean, your opposing counsel basically said, well, even if there is evidence that supports your verdict, that doesn't matter as long as, well, I'm paraphrasing, even if there's conflicting evidence, and the trial judge who sat through the trial says, yeah, but I think it's against the manifest way of the evidence, therefore that's no abuse of discretion. So because he cites the Savoya's opinion from whatever.
Yeah, well, the Hahn case, it doesn't address the circumstances. It's a recitation of black letter law without any indication what went on in that case to support the outcome. We know that judges get reversed when granting a trial based on manifest weight. This court has held that a verdict is generally not against a manifest weight when the evidence is conflicting from two or more witnesses. We know that.
Maybe I misheard your opponent's argument, but it seems like he's telling us that the case law from Tallahassee all the way through our court is basically, well, even if there's conflicting evidence, if the trial judge says, well, I just don't think your conflicting evidence, the evidence on the other side is so overwhelming that conflicting evidence is against the verdict's against the manifest weight, that basically ends the discussion for our purposes.
Well, certainly it doesn't. That suggestion that the ruling is not subject to appellate review somehow is, of course, wrong. The grounds have to be supported by the record, and there has to be articulated grounds that justify setting aside the verdict. This court, in a number of cases, has reversed, and others, consistent with the Florida Supreme Court's decision. The judge cannot act as a seventh juror. The cases tell us this. And I suppose simply having some degree of conflicting evidence doesn't necessarily mean an abuse of discretion.
I have a question that is entirely divorced from the record. If the jury had made a credibility determination, unspoken, about the plaintiffs and decided that they were just flat out malingering, And then the judge made credibility determinations about everything else in the case, said every expert that you brought in this case was full of it, and I'm throwing all that out. So all these experts are right, all yours are wrong. Would the judge be wrong to then say the manifest weight of the evidence was against us, when the only thing the jury has at that point is simply the credibility of the plaintiffs themselves?
That is, I think, yes. And had the judge in this case analyzed the evidence and said the jury in this case was against the manifest weight because Dr. Zaidi didn't answer all the questions correctly, yes, I think I would still be here saying that's an abuse of discretion because this verdict was completely sustainable on the basis that these plaintiffs lacked credibility and the jury had every right to return the verdict they did because of that. So, yes, the focus has been here on the experts. At least in the arguments, because there was nothing in the order to that effect. But Your Honor, yes, I think that's correct. If the judge's findings don't support a problem with the verdict necessarily, then I think there's a problem with the order setting aside the verdict and granting a new trial. And that could well have been a reason for the jury's verdict in this case. These plaintiffs had terrible credibility problems. The claim, the insistence that they were absolutely unconscious at the scene, that's their version of the facts. These men were walking around the scene. One was on his phone. Neither of them wanted to be treated. One of them wasn't even transported. No, the jury they went to the hospital, were discharged with sprains. The chiropractic records afterwards were mundane. Yes, they had huge credibility problems for a number of reasons. So yes, that in and of itself could have supported this verdict. I want to make sure I address all the court's questions. I don't want to repeat everything or anything I've already said. No. So we would ask the court to reverse and reinstate the verdict. Thank you.
All right, counsel, thank you.
Thank you for your time. We're adjourned.